So again, this is the estate planning strategies to preserve your wealth and really to make sure you have a game plan so that your resources go to the people and causes you care about most. Kind of in our planning here, we want to make sure that we are disclosing that this is not designed to be legal advice. This is information and educational only. And should you have specific questions, you can meet with us. We're happy to help you find the right advisors, right attorneys, tax professionals to make sure you have the best advice for your unique situation. Just a quick snapshot about me and a little story. I grew up in the Northern Virginia area, and I grew up wanting to be an investment banker. I don't know where that came from, but that's what I wanted to be. And went to graduate school in Manhattan, got a job with Goldman Sachs and Deutsche Bank working on Wall Street. And while that was great experience, I learned two really important things. First, being an investment banker is not conducive to a family. And so for me, family's super important. And two, I learned that I've got to be doing something I feel that has a positive impact on people's lives. Now, you can argue an IPO has a positive impact, but for me, it wasn't kind of the kind of impact that I wanted to have. And so I transitioned to wealth management, where it gives me a much more of an ability to have a positive impact on people's lives. And I find it immensely fulfilling to sit across from families and individuals and help them make good decisions with their money. So that's just a little snapshot on me. So you might be wondering, why is a finance guy talking about estate planning? And it really comes down to, when I was on Wall Street, I learned that there's more to wealth or to good financial decision making than picking stocks and bonds or your portfolio. There's a lot more that goes into making good financial decisions. And you can kind of see here our wealth management wheel of services, everything from investing, tax planning, retirement planning, education, borrowing, insurances, and estate planning, charitable giving, philanthropic. There's a lot that goes into making good financial decisions. And an estate plan is a component of a comprehensive wealth plan. In our view, it'd be financial malpractice to only focus on stocks and bonds and not be aware of, are your assets titled correctly? What do you want to have happen to them should you become incapacitated, or at the end of life, where do you want these things to go? So we don't look at our clients' financial lives with blinders on. We want to look at the whole comprehensive financial picture and provide the best advice there. Now, again, we don't do the tax filing. We don't do the legal work. We work with outside professionals, but we know enough about those areas that we can identify which professionals are the best for your specific situation. And also, what we also ran into when we would refer clients to trust and estate planning attorneys before meeting with us, the first question that the attorney is going to ask is, what financial assets do you have, and how are they titled? And so that's what we do when we do our initial kind of discussion, consultation with potential clients, is we go through, what do you have and how is it titled, and really give you the information you're going to need when you sit down with a trust and estate attorney. So for us, that's why we really want to highlight some things for people as they start to think about something that a lot of us put off way into the future, right? When you have to talk about, end of life care, or what do you want to have happen to your assets at the end of your life? It's not a very comfortable conversation, but it's an important conversation to make sure that you can make those decisions in a calm and in a planning way, rather than in a hurry, or in a situation where it's very highly emotional, right? You're dealing with a tragedy potentially. So that's where the financial planning piece comes in, is before you sit down with a trust and estate attorney, you want to understand, what do you have, how's it titled, and what's going to be left over potentially. How much of your asset base do you need to live out your life, and what do you think might be left over? So when we talk about what is estate planning and why do the planning, a lot of people, just assume certain things and don't really think through the questions that we need to be thinking through for a comprehensive estate plan, right? Well, some people assume, well, doesn't everything automatically go to my spouse? And we'll talk a little bit about how that gets handled here in Virginia. Well, how can I preserve more money for my heirs, right? Tax planning is an important part of estate planning, regardless of the size of your estate. And we'll talk a little bit about that. Do I have the right beneficiaries on my accounts, right? If you've got 401ks, IRAs, life insurance policies, right, you have to put a designated beneficiary. Do you have the right ones? Maybe you have a pension. Do you have the right beneficiary on your pension so that the survivor benefits go to the right people? Additionally, who knows where to find your stuff, right? This is becoming a bigger issue when a lot of our information is now online, right? Where are the passwords? What website? How do I access those? How do I shut them down? Those kinds of things as well go into an estate plan. And who gets what you have when you're gone? Have you made that decision? I had an experience, my grandmother on my father's side I was very close to. When she passed away, I have two aunts and my father, and there became some hurt feelings because they were fighting over little, trinkets that really had no value, but they were in an emotional state. And, mom promised me this, or, dad said I got this. If there's not a clear plan of who gets what, it can create hard feelings and have unintended consequences. So I want to make sure you clearly define who gets what. And then what about a trust? Wouldn't that make sense for you? And then if it is, who should be the trustee? And we'll talk about trust today as well. But also, instead of end of life, what about if you're incapacitated, through an accident or medical issues? Who gets to make the decisions, both financial and medical decisions for you in the event of incapacity? And who will take care of you? You've got young kids. Who's going to take care of the kids? And how are you going to distribute the assets that you have at what ages and for what reason? And who gets what? And who gets to decide who gets what while you have young minor children? So these are some of the things you need to start thinking through. And if you have a significant other or a spouse or someone else that is dependent on you for their financial well-being, these are some of the things you need to start thinking about and planning around for these potential situations. So why a plan? Right? If we've talked about, the financial piece of things, but why do we need a plan? Why can't we just let it happen? Right? There's laws out there. There's, you can just leave it to the people that are left after you're gone. Well, you want to make sure that you preserve and in some cases enhance the relationships of the people that you care about most with a comprehensive estate plan. What about the causes you care about? You want to make sure that if there are causes you care about, that those resources go to those causes that are important to you. And additionally, you want to be able to enjoy the time that you have and not worry about, well, what are the kids going to do or how are they going to feel if I, give them this and not this, and, worrying about the assets that you have and really feeling comfortable that you're going to be able to live out your life the way that you want and you have a game plan for whatever's left over. And in the end, really the goal for a plan, what it does is it provides peace of mind, because your estate plan is your last demonstration of love for the people that you leave behind. Now, we've been involved in a lot of these situations, and what we've seen is a significant difference between, a passing of someone that has a well-documented, thought-out estate plan and somebody that just left it, for their heirs to figure out. And the ones that leave it for their heirs to figure out, they're in a difficult, traumatic, emotional state. They're trying to deal with things and find things. They don't know where they are. They're trying to deal with things. If they're a trustee of a trust or the executor of a will, they're trying to do things that they're not normally used to doing. So it creates a lot of stress and challenge for the individual and the relationships that are most important. And those that have a comprehensive estate plan that's well documented, laid out what they want to have happen, it reinforces the relationships and demonstrates to those that are left behind that, hey, mom and dad or mom or dad, they really thought this through and allowed us to just execute their plan. And we could just remember and grieve, remember them and remember the good times and just grieve and reinforce those relationships. So when you think about a plan, it's really about making sure that your financial resources go to the people and causes you care about most. So what is your estate? This is pretty easy math, but you really want to think through and do the math so you can understand what is the size of your estate. So you can start to think about what are the tax implications and do you have enough to live out your lifetime with the assets that you have? but your estate is basically all the property that you own. And you, to figure out your total estate, then you subtract out your liabilities, right? So we have the example of Joe here, that he is has a house worth $2.1 million, a car worth 150,000, checking account with 130,000, and then a brokerage account with 3.5 million, and a mortgage on his house of 1.5 million. So you do all the math on that, and you subtract out the liabilities, and that gives you his total estate of just a little less than 4.4 million. This is something that you should have done or should do to make sure you understand what do you have, where is it, and then how is it titled, so you can really understand your estate. And then estate planning is, we'll talk about the specific documents, but it really is for you to have a discussion around how you're going to distribute your estate in an orderly and an efficient fashion upon your passing. It can deal with things like the continuation or the termination of a family or closely held business. You might be concerned about estate taxes, and in some case, income tax. What about inheritance tax? We'll talk a little bit about that. That's a unique thing that Maryland, folks in Maryland will have to deal with. And really, at the end, it's really a specific game plan. And once you have that game plan, then you can decide what documents, what structures work best for you. But really, estate planning is financial, retirement, business succession, charitable, medical, disability, legacy, and gift plan. It's just big planning that needs to go on and things you need to think through. One of the big stumbling blocks for people as they start to think about the estate plan is they think that it is in stone. But really, the part that we play is once you have your estate plan in place, we review that with you on an annual basis and say, okay, has anything changed? Have you added new assets? Do you still like the people that are going to be the trustee? Should they still be the trustee? And are there things that change? And you can make adjustments to the estate plan all the way up until death. And so it's really about getting started first and coming up with the game plan, then working through the documents and understanding that over time, those documents can change and be adjusted. So this is, who needs what? This is a quick snapshot of who needs what and in what specific scenarios. So first, almost everyone needs these things, right? Looking at how your assets are titled and your beneficiary designations, understanding those specific things. Then also you should have a will. Who gets what, when, how, especially if you have young minor kids. A power of attorney, both medical and financial. So if you do become incapacitated, people can make decisions for you, and you've made those decisions beforehand. Advanced directives, these are the living will or medical directives as well. We'll talk a little bit more about those. Some things some people might need, and most people need, but some maybe not, is life insurance, right? To make sure you have something to take care of the people that you might leave behind. And then lastly, essentials for some, maybe a trust makes sense. Maybe you need to do some complex estate tax planning to make sure you're avoiding any estate taxes. And we'll go through each one of these in detail so that you can understand where you might fit within what the needs are. So a properly crafted estate plan can help you avoid probate, and we'll talk what is probate. It also allows you to maintain control after you're gone, right? You can structure things so that you can make sure the money, again, gets used for the things that are important to you or impacts the people that you care about in the way in which you want it to impact them. It can protect your spouse and children to make sure that the assets go to them rather than, to an in-law. You can protect inheritance from creditors and divorce. You can prevent delays related to the estate settlement and estate planning. You reduce disagreements this is a big one, right? You can reduce disagreements among family members or heirs. Really, if you lay out a comprehensive estate plan, it really, in their part, should be just executing it versus having to make some difficult decisions. So let's talk about the basic estate planning documents. And they really come down into two categories. The first is how to distribute the assets, and this is really after you are gone, is a last will and testament. and a revocable living trust, potentially. Those are two elements of how to distribute the assets. And the other documents are for disability planning, right? You're still here, but for one reason or another, you are now incapacitated. And who gets to make financial and medical decisions for you? And what specific medical services and treatments do you want or don't want to have? And so as you think about those in those two different categories, you can understand which ones might apply to you. Are you more concerned about distributing the estate or about disability planning, or both? And in the end, a comprehensive estate plan should address both elements of how to distribute the assets once you're gone, and what happens if you become incapacitated while you're still alive and still here. So let's talk about the first, the last will and testament. This is your document that says, here's the instructions for distribution of your property, and it only becomes in effect upon your death. Now, all assets disposed of through a will must go through probate. So let's talk a little bit about probate and what that means. So probate is just really, it's an official court process for proving and recording your will. So this is a process where you go down to the courthouse, you have death certificates, you have a copy of the will that's been executed, and you present that to the judge and say, here's the death certificate, here's the will, here's who we are, and the process gets proved up in court. And then they go through that process to make sure that the assets gets distributed based on the will proceedings, or based on the will document. Now, the thing to understand is probate is 100% avoidable. And I've got a quick poll question here for folks. Let me know if you can answer that. Really the question is, on average, how long does it take to probate a will in Virginia? Is it 1 month? Is it 3 months? Is it 12 months? Or is it 18 months? And so I think we've given just about everybody a chance to answer that. And so I'll end that and I will share. So hopefully you can see, and this just shows you, who answered, how many people answered. And most people said 12 months. It's interesting, nobody said a month, which I guess that's understandable when you're dealing with the court system. But on average in Virginia, it takes about 18 months to go through a probate process. And so if you think about that, that now can create a long time frame in terms of when you're going to be able to finalize the process. Right. So here's the process in Virginia. So in Virginia, the process, if there is no will, is the first person to inherit is the surviving spouse. Unless there are children of someone other than the surviving spouse, in which case then a third goes to the spouse and 2/3 goes to those surviving children. So you think about maybe it's a second marriage or something like that. And now instead of it all going to the spouse that you wanted to go to without a will, now it goes to some children that maybe you weren't wanting to get some inheritance. If there's no spouse, then it goes to the children and their descendants. If there's no surviving spouse or descendants, then 100% to one or both parents. If there's no surviving spouse, no descendants or parents, then 100% to your siblings. No surviving spouse, descendants, parents, or siblings, then any family, cousins, grandparents. And if there's none of that, then the Commonwealth says, hey, we can't find anybody, then we'll take it. So there is a process if you don't have a will, but rarely do we want to leave the process to a court process rather than something that you have decided, here's who I want to get the resources that I have. And over here, when you think what's wrong with probate, there's nothing wrong with it. It's there for a reason. But some of the drawbacks are it's very public. These things have to be published. Your will has to be published. The information has to be noticed that you've passed away. And if any creditors are out there, it can be a slow process. It can be costly. It can be, probate in Virginia isn't super costly. It's the legal fees. In Virginia, you pay about $1.33 for every $1,000 that is being probated. So if you have $1 million estate and you're probating that through Virginia, it's going to cost you just a little over $1,300 to go through the court process. Now, if you have attorneys involved in the process, then all bets are off, and the cost can go much higher than that. And again, you're letting the state decide in the probate process if you don't have a will. And this process can be lengthy and cumbersome on your heirs that are trying to manage this process and understand how the process operates. So there's nothing wrong with probate. It's there for a specific reason. It's great that it's there for those that either didn't have time to do the planning or planning's out of date. But it is avoidable. So if we can avoid it, we would like you to be able to make the decisions of what happens to your assets rather than the state. And so what property does a will cover? So any property that has a beneficiary associated with it does not go through probate. So life insurance does not have to go through probate, assuming that you have the right or have a beneficiary on the policy. Retirement accounts, IRAs, 401ks, if they have a beneficiary. Joint property. So if only one person dies, but another person is on that property as a joint owner, that does not have to go through probate. Any transfer on death designations and any property in a trust does not have to go through probate. Any property that is in your name that does not have a beneficiary does need to go through probate and is part of the will. Now, one thing I want to highlight, in Virginia, there's a unique titling designation, which is called tenants by entirety. Most people title their property joint tenants with rights or survivorship. And essentially what that says is, hey, we each own this property 50-50, joint tenants. When you do joint tenants with rights or joint tenants by entirety, it says we own this entire asset together. So you might say, well, that sounds like the same thing, but the difference is joint tenants with rights or survivorship, where it says, hey, we each own 50-50 of this jointly. If spouse A gets in trouble and has a lien against them or a judgment against them, the creditors can force you to sell your 50%. Now, the other person that doesn't have the problem will get their 50% because you own it 50-50. Tenants by entirety says, no, we don't own it 50-50. We own it jointly, but in its entirety. So then it gives you some added asset protection if you title things with joint in tenants by entirety. So that's a unique titling structure in Virginia and a number of other states, but it provides a little bit more asset protection. So the short answer is if there's a beneficiary designation on an account, then it doesn't have to go through probate. So it doesn't necessarily mean you have to have a will. It doesn't mean you have to have a trust to avoid probate. You just need to make sure it has beneficiary designations, but it still makes sense to maybe have some of those documents to deal with some things that maybe you weren't able to get a beneficiary onto, like automobiles or some of the things, furniture and things that are in the home that maybe matter to you and have some value to your heirs. So that brings up the question about a revocable trust. So when you think about trust, there's a number of types of trusts out there. Most people, when they're talking about their estate plan, is a revocable trust. And it provides a set of instructions to care for you and your family during your lifetime, during incapacity, and after death. All assets disposed via a trust will not go through probate. A trust also must be funded with the assets prior to death. So you can set up the structure, but if you don't actually get the assets into the trust, and we'll talk a little bit about how to do that, then the benefits of the trust you don't get to avoid probate. So we've got to get those assets in the trust. I've got another poll question here for you. It says, true or false, if I put an asset in my revocable trust, I will be taxed if I take the assets back out. So you've established a revocable trust, you've funded the trust, and now if you take the assets out of the trust, it then becomes a taxable event. True or false? Everybody, just another minute. Great. So if I add share those results, right? So most people said false, which is correct. That's why it's the name, right? Revocable trust. There's not tax implications in a revocable trust because it's more of a legal structure. It's what the IRS refers to as a pass-through entity or a non-identified or non-recognized entity. But so when you decide to take assets out of the trust, there's no specific tax implication. So until you pass away, the trust is revocable. The second you pass away, now it becomes irrevocable and everything becomes in force at that point. So you can have a revocable trust and everything's structured correctly, but a year before you pass away, say, hey, I just don't like the structure. I want to do something else. You pull all the assets out of the revocable trust. There's no tax implications, but now the assets may have to go through probate if they don't have the beneficiary designation. So it is a completely revocable structure should you want to go down that path. So how does a revocable trust help us avoid probate? So again, with your last will, your property goes through probate court and then goes to your heirs. When you have the revocable trust and it is funded with your assets, now it transfers directly to the heirs. So I'll give you a short, simplified example, which is, let's say you have a checking account that is in John and Jane Doe's name, right? So it's joint owned by John and Jane Doe bank account. If they go in and they set up a revocable trust, which is the John and Jane Doe Family Trust, and then they retitle the assets in the name of or retitle the checking account in the name of that trust. So instead of it being John and Jane Doe joint owners, it's now John and Jane Doe Family Trust. As soon as John and Jane Doe pass away, now the trustees of that trust can step into that account, utilize that account for whatever the trust says they can utilize those funds for. Versus if they didn't have it in the revocable trust, that checking account, because there's no beneficiary, then it would have to go through probate, and they might have to wait that 18 months before they can start utilizing those assets for settling the estate or whatever the needs might be based on the will. So a revocable trust just kind of steps into that place and provides a beneficiary for all the assets that you put into the trust. The trust also allows you to be very specific about how the assets are going to be handled upon your passing, right? The example I like to use in Virginia is if you have a child, let's say the child's name's Johnny, and you can put in there, hey, Johnny gets assets out of the trust if he goes to UVA, and he doesn't get it if he goes to Virginia Tech. Right? That's an extreme, but you can get that specific within a trust as to how you want the assets to be managed, who gets them, when they get them, what are the conditions under which they get them, who's the trustee, who's the successor trustee, do they have to keep them in trust, can they take them out of the trust? So you get a lot more specific in the revocable trust, and you're able to manage the assets within the trust after your passing, versus a will is usually just a, hey, you get this, and you go through the probate process. So the trust provides a little more flexibility, a little more control after your passing. And there's a number of other benefits to a trust. Like I just mentioned, maintain control over the estate, avoid probate, potentially reduce estate and income tax, protect the spouse and children, protect heirs' inheritance from creditors, provide disability planning, prevent delays related to probate administration, reduce possible disagreements among heirs, and provide for minor children. One of the key things that we see most clients are interested in, one of the key benefits they like of a trust, is it allows them to potentially protect the assets for their children against divorce, right? So if you have children that are married, there are ways by using a trust, you can make sure those assets stay with your child rather than an in-law in the event of a divorce. So that's another element that a trust can hopefully provide, should that be of interest to you. Now let's move on to the financial power of attorneys, right? This is really just a document where you designate someone as your agent to make financial decisions on your behalf should you become incapacitated. So, let's say you had an accident, you're in a coma, but the mortgage still needs to get paid, and you've got to make sure the electricity bill still gets paid, but you're the only one on your account. So who gets to make those decisions? Who has the authority to distribute and make payments out of your bank account if you're not there? And so the financial power of attorney provides that authority on your behalf to make those financial decisions. Also, with that, another power of attorney is your medical power of attorney and living will. So your medical power of attorney is much like your financial power of attorney, where somebody's making financial decisions for you, but now who gets to make medical decisions for you in terms of what kind of care? And then the living will deals with what kind of care do you want at the end of your life, right? Your terminal, what kind of care and decisions you want to be made for you in terms of life support and medication. So providing, making some of those decisions now rather than leaving those to the people that are left behind or having to make those decisions for you and not really knowing what your wishes are. And it's important to understand the different types of powers of attorney. All right. A limited power of attorney is specific for one unique task, right? I'm going on vacation or traveling abroad. You can make specific decisions in this account and only effective while you're still alive and you have all your faculties. A general power of attorney gives you, like it states, a number of activities that you can make on your behalf and a very broad list of responsibilities. When we're talking about a financial power of attorney in terms of estate plan, usually we're dealing with a durable power of attorney. This is a power of attorney that remains in force while you are incapacitated and allows them to make those financial or medical decisions for you. And on those durable power of attorneys, there's two ways in which those become effective. And it could be a springing power of attorney where it becomes effective on some event, right? You have become incapacitated and then it takes, two doctors to confirm that you are incapacitated or not able to make decisions. So it's a little bit lengthy of a process for the power of attorney to become in effect, or just the standard durable power of attorney that just is in effect at any point in time that you become incapacitated. Now, it's important to understand that these powers of attorney terminate upon your death. So again, remember, these documents are for while you are living, but unable to make your own financial or medical decisions. So a competent estate planning attorney will be able to walk through all of these specific decisions and options available to you so you can make the best decision for you. So it's important to remember these different basic planning documents, right? The last will and the revocable trust are designed for distributing assets after you're gone. And then the other documents are for disability planning, right? Financial power of attorney, medical power of attorneys, and living wills. You're still alive. Who gets to make those specific medical and financial decisions for you? And what specific type of care do you want at the later end of life planning? Another key element when you think about your estate plan is being aware of the estate tax. Now, for a lot of people, this may not have an impact because currently the estate tax, not income tax, but a estate tax exclusion amount is just a little less than $13 million per spouse. So you think about that, that's $26 million per couple. That is exempt from estate tax. Now, it's important to be aware of this because that amount might change in 2026. Currently, the tax cuts are set to sunset or expire at the end of 2025. And in 2026, this amount is scheduled to go back down to about $6 million. So that'd be $12 million for a couple's estate. So it's important in this area, if you start including homes and 401ks, you can start to really get close to those lower numbers potentially. And so you want to plan if you think that you might be subject to estate tax. There's some planning that you can do to offset some of that estate tax and take advantage of the current exclusion amount before it reverts back to a lower amount potentially in 2026. On the other side, there's an annual estate tax exclusion amount that you can gift. So you can give anyone $17,000 a year and as many people as you want without any gift tax or estate tax implications. And that's a way to start to get some of the assets out of your estate if you think you might be hit with estate taxes at your passing. So if you're married, each of you can give $17,000 to a person. So you can really start to accelerate distribution of the estate before it gets hit with estate taxes. One other thing to be aware of, there is such a thing as an inheritance tax. So estate tax is a tax on the estate. So that's if you have an estate of, $30 million and you pass away, that 40% is going to be taxed at the estate level. There are also certain states, Maryland being one of them, that charge an inheritance tax. So a tax on people receiving the inheritance. There are also a number of states that also charge their own state estate tax. What we were talking about previously with this 40% number, that's the federal estate tax. Now that we're looking at this graphic of the United States, now we're talking about a state estate tax. And you can see in this little bubble over here, those in Virginia, there is no state estate tax and there's no inheritance tax. DC does have an estate tax, and Maryland has both an estate tax and an inheritance tax. And so you want to be aware of in DC about what the estate tax is if you live in DC. And if you're in Maryland, both if you live in Maryland and receive an inheritance or your estate is in Maryland, you want to be aware of those potential estate taxes and maybe do some planning, maybe some moving later in life to avoid both the inheritance tax and the estate tax. So when we talk about taxes, what assets are best for wealth transfer? And you can see here on the graphic, we've kind of put in a ascending order, which is the best for best for wealth transfer to avoid taxes. And one of the best vehicles is life insurance. There is no tax, income tax, and now we're talking about income tax on life insurance. There is no income tax, there is no income tax on cash transfers. And securities are great for wealth transfer because when you pass away, you get what's called a step up in basis. Meaning if I bought Apple stock for $50, held it my entire life, and now it's worth, $150. If I sell that while I'm living, I'm gonna have to pay capital gains tax on the $100 gain that I have, right? It went from 50 to 150, so there's a $50 of gain there. I would have to pay capital gains tax on that. When I pass away, and if I leave those assets to my heirs, now their basis or their tax basis in that Apple stock is now $150, not the $50. So that $100 of gain, when it transfers to your heirs, just disappears. It's what they call step up in basis. Same thing happens with real estate. Say you bought your house for $100,000, now it's worth $1 million. If you sell that house while you're living, then you have to pay capital gains tax. If we're thinking, there is a exclusion amount for primary residence, but you'd have to pay capital gains on a portion of that difference between 100,000 and $1 million. If you transfer to your heirs, now you get that step up in basis. Their tax basis in that new home now is $1 million, not the $100,000 that you paid for it. Roth IRAs are great for wealth transfer because you've already paid the tax and those assets now transfer tax-free. The reason the Roth IRAs and 401ks might not be at the top is because the IRS now requires even a Roth IRA or 401k has to be distributed or emptied over a 10-year period after your passing. It used to be that you could leave it in there your entire, the heirs' lifetime. They could leave it, both the traditional IRA and Roth IRAs, they could leave the assets in there and just take a little bit out over time. But now the laws have changed. You have to completely empty those accounts within a 10-year time frame, both a Roth IRA and a traditional IRA or 401k. And the reason your traditional IRA is at the very bottom is because any money that gets distributed out of the traditional IRA is taxable at ordinary income. So it is one of the less efficient ways to transfer wealth, unless you have some gifting that you want to do to a charity, right? A nonprofit, they don't pay those taxes. So if you're going to leave assets to a charity, some of the best assets to leave to a charity would be assets out of your traditional IRA so that they don't get taxed versus, if you leave it to one of your heirs, they're going to get taxed at ordinary income rates. So as you start to think about, hey, let me get my game plan, let me get my estate plan put together, and you have different goals for different causes, people, or charities that you care about, now you can start to think, okay, what's going to be the most tax efficient way to gift so that more of your resources go to the people and causes you care about most. Wow. So we covered a lot. And your head might be swimming. So, okay, well, that's all great. What do I do? Like, how do I decide what's best for me? And so there's a quick, just 5 steps. The first thing you need to do is get organized. Get all your documents together, get all your assets, and think through, what do I currently have and how is it titled? We're happy to be helpful in that process. We have an initial consultation that we do where we help you get organized and think through how much do you need? What are your goals? What are the timeframes for your goals? Who matters to you? What causes matter? So you can really conduct this needs analysis so you can understand how much of my asset base do I need and want to spend for my lifetime, and what might be left over. Because that'll be helpful to a trust and estate attorney to figure out, well, do we need to be concerned about estate taxes? Do we need to be concerned about inheritance taxes? So that they can structure a plan that works to accomplish your goals. Then once you've got that, then you establish the estate plan, right? Working with an attorney, you can put all these documents together, whether you need a trust or not. They can help you work through those specific decisions. Then once you have your estate plan put together, you're not done. Unfortunately, when we start meeting with new prospective clients, we ask them, hey, have you done any estate planning? They're like, oh yeah, I did that years ago. And we say, great, where is it? And they pull something out of, under their bed, they blow off all the dust, and they're like, oh, here it is. And we come to find out they did all the paperwork, but they didn't actually implement the plan. So for example, when we talked about that checking account that we example for John and Jane Doe, if you do not retitle assets into the name of the trust, they don't actually get into the trust and avoid probate. So these are things like real estate, brokerage accounts, changing beneficiaries on 401ks and IRAs, and on life insurance policies and real estate, and all of those things. You need to make sure that you implement the plan. And what we do is a beneficiary audit. So we go through all the assets that you have. What happens to this asset should something happen to Joe or something happens to Jane? So we now understand who's going to get it. And then we work with you and say, is that where you want the asset to go? Is that what we want to have happen? And we can also talk through the specific tax implications of those beneficiaries as well. And then, unfortunately, not completely done. Even when you've got that, you need to review it on an annual basis, right? Have we acquired any new assets? Do we have a new condo that we've purchased? Or did we open another bank account or brokerage account? Do we need to retitle those? Do we need to have beneficiaries? Did I change jobs? Do I still want my brother-in-law to be the trustee? Or now do we want my older grown child to now be the trustee of the estate? Have my kids gotten married? Do we need to account for that? So there's a lot that goes on in making sure the estate plan is up to date on an annual basis. And that's what we come to for us. For us, a lot of this is just educational. We want to be helpful and add value. And ultimately, if that leads to a long-term business relationship, that's great. If not, we hope you are armed with information that helps you make good decisions so that your money and resources go to the people and causes you care about most. And our initial consultation, if you'd like, at the bottom there, you can see, our calendar link. You can get on our calendar. Happy to do a phone call, because what we've done here is we've talked about in generalities. Here's what the things are. You might have specific questions. Well, I've got a special needs child. How do I structure things around that? And we can give you some preliminary direction and help you find the right trust and estate attorney to help you with those specific unique needs. But really is an opportunity for you to share with us your unique situation and for us to help you make good decisions around some of the general information that we've provided to you. And feel free to look us up online. We're very pleased with the reviews that our clients have given us. And we strive to constantly add value and really be helpful, and not through a sales process. We are not looking to implement a product. We're looking to provide a valuable service to you and our clients so that you can make good financial decisions. If that means a long-term business relationship, great. If not, that's okay too. Hopefully you've got some information that will help you make good decisions so that you can enjoy your resources to accomplish the goals that you have. Additionally, we have a number of resources that we can make available to you. You can either put your information in the chat, and we're happy to share these. One is this brochure, more about why you need an estate plan and what all the elements are. There's another document that helps you go through your asset inventory. What do you have? How is it titled? And then also a workbook to help you go through your own beneficiary audit, to think through what resources do I have, how are they titled, and how do I maybe need to change those. In the end, it's important to remember why have a plan, whether it's financial or estate plan. It really is to make sure that you are impacting the people that you care about most with the resources that you have, that you're having that impact that you care about, that you're impacting the causes you care about, that you're able to enjoy what you have now without concern about how it might negatively impact the people that you leave behind. And really gives you that peace of mind that everything is taken care of, it's tied up with a nice little bow, and your heirs don't need to worry about making decisions about how things need to be handled, because you've already made those decisions for them. So they can just remember you, remember the good times, and execute the plan that you've put together for them. And remember, your estate plan is your last indication of love to those that you leave behind. And it really does make a difference. It allows them to remember the good times, to remember you, and not have to make difficult decisions that they may or may not be equipped to make. So I hope this has been helpful. I hope that you have gotten some information that you can now implement in your unique situation. I also hope you'll take us up on that, initial consultation. There's no pressure. There's no sales. It really is just an opportunity for us to get to know each other a little bit better, see if there's something that we can do jointly moving forward. If not, that's okay too. So I appreciate your time. Thank you for spending a little bit of it with us today. I'll take just a minute to look through some of the Q&A and hopefully answer some of those for you. I've got one question that says, if I leave to my only son a rental property under a 1031, I don't know if I've got the full answer there. For a question. Well, it says, if I leave my only son a rental property under 1031. So there's actually two questions going on there. One is a 1031 exchange, which is a tax strategy of deferring gains on a rental property or an investment property and rolling those gains from one property to another. So that would be a 1031 exchange. Now, leaving a property to your son, yes, you would actually get a step up in basis. So let's say you owned this rental property, you've put a whole bunch of gains in there, and the rental property cost you $1 million, and there's $500,000 of gain in there. If you leave that real estate asset to your son, then he gets a step up in basis, and that gain that you've been deferring through a 1031 exchange disappears. It's a really unique strategy. So yes, if you've been deferring gains through a 1031 exchange process, then yeah, you can ultimately get that benefit of a step up in basis. So again, thank you for your time. If you have more specific questions, you can use that Calendly link that I think is also being put in the chat at the bottom, and also some contact information from someone in our team that you can also reach out to try and schedule some time. Again, our goal here is to really be helpful, help you get the information that you need so you can make good decisions, so that you can enjoy the resources that you have and make sure that you're having the most positive impact on the people and causes you care about most. Thanks again, and have a great rest of your day.